Let's talk about the 3 C's. And those I'm going to say today are civil cases, what I've always discussed with you and what my website is dedicated to. Civility, how you act in a courtroom or how you interact with other people throughout the course of a case. And the 3rd C is closing. What does a closing argument look like in a civil case? Let's discuss the 3rd because it incorporates the qualities of civility in a civil case. You start off in a closing argument by thanking people for the attention that they've brought to a case. And I said people because it not necessarily is a jury, it could be a judge. And I want to point out that if the case, as most doesn't try, you still want to act with your adversaries and you want your client in a deposition and otherwise to act, as I say, politely but firmly. Always be polite, but never be unfirm such that you are hoodwinked or cajoled or intimidated into saying something you don't believe. Going to the closings, I start off and I thank people for coming day after day to a trial and disrupting their schedule. I secondly thank them for the attention and care they'll give the case in the jury deliberation room. That really needs to be noted because the time spent up to the time of deliberation and the time in deliberation is time away from someone's schedule. I thirdly say that the judge will instruct the jury, if it is a jury, on the law, and that it is their job to find as fact finder what the evidence is and to make certain determinations based on the evidence they heard, saw, and the so-called reasonable inferences. One of the major things I speak about is credibility. They, that is the jury or the fact finder, is the ultimate judge of the credibility of who comes before them to testify. And those are the kinds of decisions that people make in their everyday life. That's the same kind of evaluation that is made. You're evaluating credibility. And of course, I discuss the standard that a jury in the kinds of cases I do, civil cases, has when evaluating the evidence. It is a standard of a preponderance of evidence, more probable than not, than it is to a reasonable degree or to a beyond a reasonable doubt. Because beyond a reasonable doubt is, as we've said, especially in the recent blogs discussing the O.J. Simpson trial, is a criminal standard, reasonable doubt. So those are the overarching themes that are addressed in a closing argument in a civil case, always conducted, hopefully, in a civil manner. Thank you.